the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone. Welcome to the Fair Housing Insiders Case Files with Leslie Tucker, the principal at Williams, Edelstein, and Tucker. I'm your host, Jonathan Sarr. Today, we are focusing on a case regarding troubles that can result from utilizing screening software. The case highlights the dangers of screening software and how it resulted in one company being accused of disparate impact. Name of the case is Lewis versus Safe Rent. Leslie, can you give us some more details?
Yeah, absolutely. And this is just one of several cases that have been filed in the last couple of years, kind of dealing with this same issue. This particular case is out of Massachusetts, and it's about algorithms, essentially, and how they can potentially reach outcomes that have a disparate impact on African American and Hispanic applicants. The plaintiffs in this case say that the housing provider's screening software, which is Safe Rent, it denied their application based on an overall screening score, right? Which is how just about all these software programs work. Mm-hmm. And that score is based on an algorithm. They allege that the algorithm input into this software takes into consideration factors that disproportionately disadvantage African American and Hispanic applicants, like credit history and non-tenancy related debts.
Very good.
Both of the plaintiffs in this case were using housing choice vouchers, which they claim kind of supports the fact that they, of course, can pay their rent because they have vouchers. So the things that they were being screened for really weren't relevant to whether they would be able to pay their rent, their credit history and whatnot. So therefore, they shouldn't have been screened for those things in the first place. And they also claim that African American and Hispanic applicants are more likely to have lower credit scores and more likely to use vouchers to pay their rent than white applicants. And that, of course, is going to take a lot of statistics to prove in this case, as in all disparate impact cases. Both the screening company, Safe Rent, and the management company of the property are named in this lawsuit as defendants. And currently it is still an active case.
Okay. Thank you. Lots of details in that case. Appreciate your summary. So just a few questions for you, Leslie, for our audience to help them understand how this applies to maybe a situation they could be facing. If screening software is unaware of an applicant's race, national origin, etc., how can it discriminate against the applicant?
Well, it's a great question. And, really that's the main reason, or it's one of the main reasons that a lot of companies use screening software, is that it sort of takes that decision out of the office and, into a software program who has no knowledge of these protected categories. They are running a consistent criteria for every single applicant and generating a score. So the screening software is not really in and of itself discriminating against the applicants. It's the algorithms that are input, the criteria that are input into the software. And again, this is not alleging that the management companies are intentionally discriminating on the basis of race or national origin. It's saying that these criteria that are being screened for unintentionally negatively impact these particular demographic groups. And that's the basis of the case. And again, it is going to take a lot of statistical evidence to prove this case.
Okay. Interesting. So if the algorithms are run by the screening software, how can the housing provider be liable?
Well, and I'm sure that's certainly an argument that the housing provider is making. But the housing providers are typically named in these lawsuits because the housing provider is the one who is coming up with the criteria in their policy, and then inputting it into the software to run for every application. So it's not just the screening software; it's the criteria that's generated by the housing provider in the first place.
Got it. Okay. So does this case mean that using screening software is no longer safe for management companies?
No, I don't think that's what you should take from this. Using screening software is incredibly common, and it's incredibly effective and efficient for operating your business, and making sure that every applicant is kind of subject to the same criteria every time. I still think it's absolutely fine to use screening software. The only thing that's really important and that can get companies into trouble is if your criteria that you are kind of inputting into the software is not, related to tenancy. It's not thoughtful. It's not sort of narrowly tailored. And also, it's important to give applicants the opportunity to appeal those decisions so they can bring to light whatever issues they think are present. That's another way to show that you are taking into consideration any of these potentially, discriminatory issues that an applicant may think is present.
Okay, very good. Thank you, Leslie. Appreciate your insight on this particular case. Thank you, everyone, for tuning into our show. This concludes episode 2 of the Fair Housing Insiders Case Files. Until next time, thanks, everyone.